Hello there, my name is Emerson Holmes. I am head of the manufacturing industrial sector here at Hogan Lovells. Today I'm joined by my partner Markus Burgstaller, who is a partner in the International Arbitration Group here in London. Markus specialises in advising and representing clients in investor-state arbitrations. In circumstances where many of our clients in the manufacturing and industrial sector are considering investing sometimes hundreds of millions or if not billions of dollars in countries where they perhaps have not invested before, we thought it'd be a good opportunity to provide our clients and others with Markus's insights into how you might go about protecting your investments, either via relying upon investor-state treaties or in an arbitration. Markus, could you just provide us, please, with an overview of investor-state arbitrations and investor-state treaties?
Thank you very much, Emerson. Investment treaties are treaties concluded between two states, which enable investors, as defined in the investment treaty, who have made investments in the host state of the investment, to bring claims before an international tribunal for internationally wrongful conduct by the host state. So you need to fulfill at least two requirements in order to be protected. You need to be an investor, as defined in the investment treaty, of the home state of the investor, which is typically if you hold the nationality as an individual, or if you are incorporated in a state, then you would be deemed a national of that state. Mm-hmm. Some investment treaties would also have additional requirements, such as that you would have to have substantial business activities or a seat in the home jurisdiction of your investment. But in some, and in fact in quite a few investment treaties, the mere incorporation would suffice. Mm-hmm. For example, most UK investment treaties would only have an incorporation requirement, meaning if as a company you're incorporated in England and Wales, you would be deemed an investor of the United Kingdom under most UK's investment treaties. Mm-hmm. And then you have to have made an investment in order to be protected. So the investment could be, for example, a shareholding in a locally incorporated company, or it could be a factory, or it could be any other investment that you have made in the host state of the investment. If you fulfill these two requirements, then you would typically be protected under an investment treaty. Mm-hmm. These investment treaties then have typical investment protection guarantees, such as the protection against uncompensated expropriation, or the obligation to accord fair and equitable treatment to investments. Mm-hmm. So these are investment protection guarantees that the host state of the investment has signed up to. And if these requirements are not fulfilled in the view of the investor, it could bring a claim before an international tribunal, mm-hmm, alleging breach of the host state investment protection guarantees in the investment treaty. And then, as is the case in investment arbitration, as well as in commercial arbitration, you would have a tribunal typically of three arbitrators sitting over that case and deciding whether the state, in fact, then has breached, subject to its jurisdiction, mm-hmm, breached investment protection guarantees, and would typically, if successful, order the host state then to pay compensation to the successful investor. So that's, in a nutshell, what investor-state arbitration is about.
Thanks very much, Markus. I thought that was very useful, as it were, overview of investor-state arbitrations. And we'll come on to discuss some of the guarantees that you highlighted there. But based upon what you said, are all countries signatories to investor-state treaties? Or are there some countries that are not signatories to investor-state treaties?
So it's pretty widespread. There are more than 2,500 investment treaties in force, both of bilateral as multilateral nature. Of course, there are some countries who have more investment treaties in place than others. The country with more investment treaties in place than any other country is Germany. The UK is also ranking very high. China is another country with a vast network of investment treaties. And there would be other countries with fewer or indeed no investment treaties in place. Brazil is one significant jurisdiction that has no investment treaties in force.
Does the United States, are they signatories to investment treaties?
Yes, the number is relatively limited, so not as significant as the UK or Germany, but yes, the United States also has signed up to a number of investment treaties, about 40 or so, as well as multilateral treaties such as the legacy NAFTA or the USMCA, that is the successor of the NAFTA. But the number of investment treaties in force in relation to the United States is more limited, as compared to, for example, Germany or the UK or other European jurisdictions.
Wonderful. Thanks for that, Marcus. So it seems to me as though investment treaty arbitration could be very important for companies who operate in the M&I, the manufacturing industrials sector, because those businesses tend to invest for the long term. They also are very location-specific investments. So, for example, they may want to invest in a manufacturing facility in the United States, or maybe in Germany, or maybe in the UK. And therefore, those investments are going to be highly exposed to government actions. These are the guarantees that you talked about earlier. Is that right, as an overview of how the entities in the M&I sector would be relying upon investment treaty arbitrations?
Yes. So there are a number of statistics out there, and it's always difficult to differentiate the sectors and what exactly is understood. But if one looks at the most recent statistics by ICSID, which is short for the International Center for the Settlement of Investment Disputes, where about 2/3 or so of all investment treaty disputes are being arbitrated before, you see that about 50% of all these disputes are oil, gas, mining, other energy. So there could be some manufacturing disputes among those. And if you look then at construction, in particular chemicals, transportation and the like, you have about another third or so.
Right.
So altogether, the vast majority of investor-state disputes are either manufacturing, industrials, and even more so energy. There are very few disputes outside of these sectors as far as investor-state is concerned. There are a few in the life sciences, in finance, in communications, but the vast majority are energy-related, construction-related disputes.
Great. I wonder now whether we can just unpack some of the guarantees that you talked about earlier, Marcus. And I think you said that one of the guarantees or the protections that these treaties offer is protection against expropriation or nationalization. How do investor treaties protect entities from expropriation or nationalization? And what is meant by those two concepts?
Thank you. So nationalization is really a term for widespread expropriation in the number of businesses within one sector. So if you nationalize, say, a sector, say, the finance sector, then that you talk about a nationalization. Expropriation would be a measure targeting one business. Then you typically talk about an expropriation. So nationalization is a widespread measure of expropriation targeting an entire sector of an economy. And then within expropriation, you have direct expropriation and indirect expropriation. Direct expropriation takes away the title to property. These are less common than indirect expropriations because, subject to a few exceptions, where a government would target a business or maybe even an entire industry with an expropriation degree. Governments are more sophisticated typically when they target measures towards a certain business. And then you talk of indirect expropriation. And indirect expropriation is typically understood as keeping the title of property to the investor, but would amount to a substantial deprivation of the value of the investment of the investor. That is typically what international tribunals look at, whether there was such a substantial deprivation of the value of the investment. So the threshold, will come probably to other investment protection guarantees later, is reasonably high and historically has proven more difficult than other investment protection guarantee. There are, of course, some treaties where you would have, as an investor, have to argue expropriation or the expropriation and being uncompensated. And there may not be the opportunity to plead other investment protection guarantees simply because the applicable investment treaty would not provide for another investment protection guarantee. So if you are, so to say, forced as an investor to plead expropriation, you need to be aware that the standard is reasonably high and more difficult to overcome than other investment protection guarantees.
In a previous podcast, we had a discussion with one of my partners about, one of our partners, about critical minerals. And that's always in the news at the moment. And the way in which you're describing these sectors and expropriation of particular sectors, could that extend to critical minerals as well? So there's particular land with lots of critical minerals in, an investor may have invested in those lands, but given what's happening in the world and the geopolitical situation, a government may want to expropriate or target that particular land with all the critical minerals in. Would that fact pattern give rise to a potential investors' treaty arbitration?
Yes, and we see that frequently, in particular in Latin America,
Right.
as well as in Africa, where we see a number of measures by governments, both targeting licenses that have been given away or land. New government comes in power, and then the investor would be able to bring a claim for protection against uncompensated expropriation, or probably more likely to succeed, a violation of the obligation to accord fair and equal treatment to the investments of an investor. So we see in particular, looking, for example, at Africa and mining in Africa, which is very important also to the energy transition, we see relatively stable number of investment claims, but we see growth in particular with respect to the energy transition, in particular in Africa as well as Latin America.
That's good to know. The second protection I think you described at the outset, Marcus, was if there was going to be any sudden regulatory changes that could impact the profitability of an investment. Could you just expand upon that? What regulatory changes do you have in mind? And to what extent do those regulatory changes need to have a direct impact on the profitability of an investment?
So the international arbitral practice that has developed with respect to changes in the legislative or regulatory framework typically speaks of fundamental or radical changes. As with many other concepts in investor-state arbitration, that looks and sounds, and probably is, slightly vague. So it's very fact-intense. So you need to look as an international tribunal, what was the legislative, the regulatory framework at the time of the investment? And how did that change over time? So was it that the investor had a legitimate expectation that assurances, for example, were given by the host state government such that the framework would stay as it is, or would at least stay roughly as it is? And if you then have a fundamental change, for example, you had no tax and then suddenly you would impose a tax of very significant amount, which would then amount to a radical change, then a tribunal may well say, look, at the outset of the investment, there was no tax imposed, there was no talk of any tax being imposed, and suddenly out of nowhere and with no justification, you targeted that sector and you imposed a tax of X%, for example. Or you changed a license approval system which was previously differently regulated, and then suddenly you backpedal, you made assurances to the investor, and then you backpedal and completely change the licensing regime, for example. So the words the tribunal tend to use were fundamental and radical changes. It looks vague, but when you go through the analysis, it shows that tribunals look very carefully, what did it look like at the outset of the investment? How did it change over time? Were assurances given at the outset, which is difficult to evidence for most investors because governments tend to be sophisticated enough in order not to leave a paper trail and sit around meetings and have agreed meeting notes and then say, we assure you that for the next 10 years it stays as it is. So what you then need to do as investors, obviously, to look at evidence that either you have internal notes or you have meeting notes or you have witness evidence corroborating what some documents may say. But this is very fact intense typically, and you need to look whether these changes were radical or fundamental, whatever that means in the eyes of the tribunal.
And I think in your answer there, Marcus, which I thought was really helpful, you mentioned that there was no legitimate basis for the change in the regulations. I'm just thinking, for example, a number of countries are now talking about national security and changes in regulations because of a national security concern. Does national security and the concept of national security come into play when considering regulatory changes?
Yes, it does. And we have seen a number of recent cases where national security concerns have played a role. The most important, perhaps, or most advanced case is the case that was brought by UY against Sweden.
Right.
This related to licenses given away by the Swedish regulator, and which effectively excluded UY from bidding. UY then brought a claim under the Sweden-China Investment Treaty. This is a case that is running for a number of years now. A hearing took place here in London in November and December 2024, so which may come to a final decision fairly soon. And obviously the measure in this case by the Swedish government, as in other cases as well, was based on national security grounds.
Right.
Because there was, a lot of concern about UY getting access to certain information that the Swedish government did not feel comfortable with, and there was obviously also pressure from other governments, which made it difficult for the Swedish government to, proceed as UI wanted it to proceed. Yeah. Similar measures in the national security space were taken by the Canadian government. A company called Hikvision also threatened a claim against the Canadian government. And there is a more recent example concerning the Netherlands, where Wingtech, a Chinese company, also threatened claims against the Dutch government. When it was known that, I think on 15 October 2025, that company threatened claims over measures by the Dutch government, which effectively took away the decision for Nesperia to continue to operate in the Netherlands.
That's great. We'll come on to the Wintech decision, I think, or that case a little bit later. But just going back again to something that you're talking about in terms of national security, just because it's so important now, I think, and it's at the forefront of a lot of people's minds when they're investing in countries. Is it usually the case that arbitral tribunals defer to the national government when they waive national security considerations? In English jurisprudence and maybe in jurisprudence across the world, national courts tend to defer to governments when they raise a national security concern. Is that the case in arbitration, or do they look at things very differently?
Yes, it's fairly similar,
right,
in a sense that international tribunals do not typically sit over decisions which really go to national security concerns of governments and sit there and say, well, we would have decided differently. So international tribunals are very restrained in putting themselves in the shoes of national security decisions. It would also trigger a very significant backlash, of which there has been some already, if suddenly 3 arbitrators the public has never known about sit somewhere in a hearing room in London or in Washington or elsewhere, and then step in the shoes of a government that made decisions based on evidence or real concerns. Of course, if it was an arbitrary decision-making, which has no rational basis, where there was no real basis for the decision-making, then there may be an angle, I think, for investors to make a more robust case. But principally speaking, international tribunals, international courts in general, are very reluctant to step in the shoes of the decision maker when national security is concerned, and is concerned in a way that the tribunal feels comfortable that there was really not a made-up ground, but there were really national security concerns for the government's decision making.
Wonderful, thanks, Markus. Just going back again to the guarantees that we're discussing. And the third guarantee, I think, is protection against discriminatory treatment favouring local competitors. I just whether you can just expand upon that particular guarantee protection, Markus.
So discrimination comes into play in numerous aspects. I had previously mentioned fair and equitable treatment. Fair and equitable treatment is the most important, statistics suggest, and international arbitral practice suggests, investment protection guarantee. This is contained in investment treaties. That also contains a protection against non-discrimination. So whenever governments discriminate in favor of national companies, that could violate the fair and equitable treatment provision. There is also a national treatment obligation enshrined in most investment treaties, which also comes into play, whereby governments are obliged to treat foreign investors, if they're protected under an investment treaty, the same as national investors or national investments that were made by national companies.
Right.
So typically, it's seen by tribunals to be enshrined in the fair and equitable treatment provision and is also wrapped up in the discussion of fair and equitable treatment.
Really? Are there some examples of where tribunals have found that a particular law or a particular regulation is found in favour of local companies and therefore is discriminatory?
There have been a number of cases, but governments tend to be slightly more sophisticated these days. So they would find measures which do not single out a national company and favor that national company over a foreign investor.
Yeah.
So other ways are typically found in order to favor a national company as compared to a foreign investor. So that is very rare for governments to say, I take away the license, for example, of the foreign investor and hand it to the domestic competitor.
Yeah.
So other ways and more sophisticated ways are found. Not so much perhaps by looking at the obligations under investment treaties, but simply also as a matter of politics, it does not look very good for most governments to do discrimination in a very open manner.
Brilliant. The final guarantee that I just want to explore with you, Markus, is maybe delays or revocation or denial of particular licenses. That could be, I suppose, for licenses for zoning, for a particular plant, for example, or particular power plant is another example. How do investment treaties protect entities from these types of issues?
It does, again, in many cases, come under the umbrella of fair and equitable treatment. It could be that a significant delay would amount to a violation of due process under fair and equitable treatment. There is also a different prong that you may have to argue, and that is denial of justice. Denial of justice can not only be argued in court proceedings, but also in relation to administrative proceedings. And as the saying goes, justice delayed is justice denied. So if these administrative or court proceedings take longer, then under the protection against denial of justice, then that may violate that obligation as well. But tribunals, again, have been fairly reluctant here to find a denial of justice. In particular, it needs to be shown that there was not just a delay in one proceeding, but almost as it were the entire system in this state that would be not really functioning.
Okay.
So just because
threshold,
because a court or administrative proceedings took a year or two or three or four, that alone would not suffice in order to find a denial of justice. So historically, and that hasn't changed a lot over the years, tribunals have said that there would really have to be a fundamental problem as a matter of principle with the system of, say, awarding licenses or the court proceedings, such that there would be a denial of justice.
Great. So I suppose going back to companies who are thinking about investing in countries across the world, it could be Saudi Arabia, it could be the United States, it could be China. How do they set up their investments? How do they structure their investments so they could avail themselves of investment treaties? So
what you typically do as a sophisticated investor, if you go into a new country, is that you work with your corporate and your tax lawyers as well as your investment lawyers to find the best structure for your investment. Typically, corporate and tax in particular considerations would be at the forefront of any investor's mind. However, in particular, if you invest in jurisdictions where you could foresee a problem later on, it may well be that investment structuring considerations also come into play. So if you invest in a country, take Saudi Arabia that you mentioned, what you would be doing is that you look what countries does the host state jurisdiction, say Saudi Arabia, have an investment treaty in force with. So the number of Saudi investment treaties is fairly limited, but you have a number of jurisdictions that in principle come into play. Of course, Saudi Arabia has investment treaties with a number of countries in the region, but those jurisdictions do not tend to be very favorable from a corporate and from a tax perspective. Right. So looking at Saudi Arabia, for example, one option could be There is a treaty in force with Singapore. That could be an option. There is a treaty in force with Belgium and Luxembourg, which in particular is favorable in a number of cases when you consider tax considerations. So there are a number of options in most jurisdictions that are more sensible than others from the outset, simply because of the jurisdictions that have an investment treaty in force, general investment climate in the host state as well as the home state, and in particular tax considerations. So if you look at the number of investment claims brought, for example, under Dutch treaties or under Belgian and Luxembourg treaties, is significantly higher than you would expect. And the simple reason is that many investors have picked these jurisdictions when structuring their investment. That Dutch treaties tend to be favorable for investment structuring and tax structuring. Luxembourg companies tend to be favorable. So you have a lot more claims brought under Dutch and Belgian and Luxembourg treaties than would really fit the size of these jurisdictions.
Just taking the example of, say, the Singapore and Saudi Arabia investment treaty, as I understand it, you have to have some kind of presence in Singapore in order to avail yourself of that treaty. What type of establishment do you have to have in Singapore? For example, could it be just a PO box? You've just registered a company and you're routing all your investments through that company. You don't have any staff. You might not even have an office. It's just a PO box. Or does it have to be something more substantial? And if it has to be something more substantial, how much more?
Yeah, it depends on the definition of investor in the applicable investment treaty. Some treaties, as I'd mentioned, have a mere incorporation requirement, which means that a PO box company would suffice. Right. Other companies, in order to avail themselves from investment protection guarantees, need to have a presence. I mentioned, for example, the Netherlands and Luxembourg previously. So most Dutch treaties, for example, have a mere incorporation requirement. So that would suffice. In Luxembourg, you frequently find the definition of investor that you have to have not only incorporated a company in Belgium or in Luxembourg, more likely in Luxembourg for tax treaties purposes, but also that you have to have your seat in Luxembourg. Then the question, and this goes to your question, is what does a seat mean? That is then typically a question of local law, but there is also international arbitral practice that developed over time. What does a seat, or as you find, for example, in many Swiss treaties, what substantial economic activities or substantial business activities mean? If you have this requirement, then tribunals typically look whether management decisions are being made in that jurisdiction, whether there is staff there, that people are on the payroll there, the taxes are paid in that jurisdiction, that management meetings take place, that there is more than a PO box. So it's not a set number of factors, but in particular, whether there is some managerial control and some people being employed in that jurisdiction is what tribunals tend to look at.
Well, thanks, Markus. But moving on to a slightly separate topic, and it's tariffs. We hear about tariffs almost every day, if not every day, then certainly every week, coming from the US. You mentioned previously that the US do have a number of treaties that they are signatories to that offer protection for investors. Do you see that there is an overlap between tariffs being imposed by the administration in the US and investor state arbitrations and investor state treaties? So investors can avail themselves of certain treaties if they are caught by tariffs?
Yes, they can, is the short answer, but we haven't seen a flood of claims, to put it mildly, at the moment. So a tax is similar in its effect than tariffs can be. So in that sense, a tariff can operate as a tax for some investors, and therefore may be actionable as well under investment treaties. In order to avail yourself of the investment protection guarantees, you have to have made an investment already. So as an entry barrier, it's more difficult than for you to argue that tariffs have been imposed. But assume that you have already made investments in the past, and then you're hit by a tariff. Then if you're protected under an investment treaty, unless there is a carve-out for tax, which some investment treaties have, or tariffs, then you may avail yourself of the protection of an investment treaty. Now, Why has there not been yet a flood of claims? First of all, the United States has a limited number of investment treaties in force. If you look at the countries with which the US has investment treaties in force, you see in particular that the major economies, in particular in Asia, as well as in Europe, do not have investment treaties in force with the United States. In particular, the largest European economies, for example, Germany, France, the UK, Italy, Spain, and the like, they do not have an investment treaty in force. Only former Eastern European countries, so for example, Poland, the Czech Republic, Slovakia, the Baltic states, Estonia, Lithuania, Latvia, they all have investment treaties in force with the United States. But they haven't brought, or any other country, to the best of my knowledge, claims against the United States for the imposition of tariffs. I don't think that any claim against the United States in the history of investment arbitration has been successful.
Right.
So they have a very good track record as well.
Yeah.
And it probably is also not at the forefront of most investors to bring a claim against the United States. It would probably not go down too well with the administration if you were to bring a claim for tariffs being imposed. But in principle, unless there is a carve-out, and if you're protected, nothing should prevent you, as a matter of law, to bring a claim for the imposition of tariffs.
Is there a time limit that you have to comply with to bring an investor state arbitration, Markus? So, for example, in like general commercial disputes, we obviously have like 3 years or 6 years or 12 years as limitation periods, certainly in English law. Is there something similar in investor state disputes?
As a matter of international law, as a matter of principle, there is no statute of limitations. Right. Some investment treaties have provisions which foresee that claims need to be brought within 3 years from the dispute becoming known, or the facts of the dispute becoming known, or should have become known to the investor. But that's rare, and that's the exception. We see some investment treaties that have that provision, but the principle is, and unless there is such a provision in the applicable investment treaty, the principle is there is no statute of limitations. So the vast majority of cases, there would be no statute of limitations because there is no principle under international law.
Right, that's good to know. But one of the, I think, highest profile potential ICSID arbitrations in the manufacturing sector involves a case which you mentioned already, which is Wingtech versus the Netherlands. Could you just please provide us with an overview of that case? As I understand it, it hasn't been referred to arbitration yet. Is at a pre-arbitral phase, but could you just provide us a bit of an overview of that case?
Yes. So that case is a threatened case by Wingtech under the Netherlands-China investment treaty. So as I mentioned previously, China has a number of investment treaties, and one is also with the Netherlands. So it was end of September, following reports that parts of Nexperia would be relocated to China, that the Dutch Minister of Economic Affairs signed an order under the so-called Goods and Availability Act in the Netherlands, which was dormant, I understand, for dozens of years, if not more, granting the state powers to block or reverse any corporate decision of Nexperia if they are deemed, quote, potentially harmful to the interests of the company, to its future as a Dutch company and European enterprise. So obviously the stakes in this case are very high. Why? Because Nexperia manufactures low-margin semiconductors for a wide range of industrial applications and playing a critical role, in particular for Europe's automotive supply chain. So the company has been owned by a Chinese company called Wingtech Technology, and that company then condemned, obviously, the Dutch government's move. And threatened claims under the Dutch-Netherlands investment treaty. So they sent what is called a notice of dispute, understand on 15 October. So many investment treaties provide for this requirement to file a notice of dispute before you can launch arbitration. There are some investment treaties who don't, but most have. In this case, there is a so-called 6-month notice period or waiting period, meaning within 6 months, if there is no amicable settlement of the dispute, Wingtech could start arbitration, which would then be 15 April. So in about 2 months' time or so, Wingtech could bring a claim against these measures by the Dutch government with respect to Wingtech. So whether or not they bring the claim or not is yet to be seen, but in principle, they can after the expiry of the 6 months period. So in 2 months' time, they could bring this action. And that would be, as for example, I mentioned the UI case, another case where a European government has taken measures on the ground of national security. And that probably would also be a case then before the World Bank's International Center for the Settlement of Investment Disputes.
Thanks very much, Markus. It's certainly a case which, certainly in the M&I sector, we should be keeping an eye on, and let's see what happens in April of this year. So that concludes our discussion, Markus. I think that's been incredibly useful. Hopefully clients and contacts will have got quite a lot of information from what you've said. It's quite clear that this is really an important area that companies should be considering as they're investing throughout the world. Thank you, Markus.